Prepared to do my closing remarks. Just one quick motion to amend the date to include September 27th, or excuse me, April 27th, so it would be April 26th and April 27th, 2013.
No objection.
That would be, information will be so amended. And you may proceed, Mr.
Thank you, Judge. Ladies and gentlemen, the first order of business for me is to thank you. I know, boy, it seems like about 2 months ago we started this process, and it's been a long one. And you guys have shown great, great honesty, great restraint, and great patience. And I certainly appreciate that. I've been doing this now for 19 years, hopefully for another 10 or 15 more. And I always say when I talk to the jury at the end of a trial that we really appreciate your service, because I truly believe that a jury is the heartbeat of the criminal justice system. Without you, we can't function. And so it goes without saying, I guess, that you guys have really earned your money these last couple of weeks, so thank you. We're talking about an incident that happened April 26th and 27th of 2013 here in Muskegon County. And I want to remind, as I did my opening, I want to remind you of some of the commitments that we made to one another at the beginning of this process. First and foremost, the fact that the court is going to instruct you on the use of other acts evidence, that it is relevant. In other words, you are to consider it and can consider it because the court allowed you to hear it. And it's there to help you determine a few things in this case, in particular intent, in particular common plan, scheme, or system in doing an act, and more importantly, identity and the fact that Jessica Herringa is deceased. The other thing that we talked about that I want to remind you is the idea of direct and circumstantial evidence, the idea that both direct and circumstantial, whether by themselves or in combination with one another, are perfectly relevant pieces of evidence that you are to use and consider in making your decision in this case. And I go back to the example I gave during the voir dire process. My oldest son and the cookies. That's the type of evidence that we're talking about, ladies and gentlemen. We're talking about those things that lead to conclusions. And that's the type of evidence that you're allowed to use in every single element that I'm required to prove. So let's get right to it. As you're going to hear at the end of closing arguments, there are 2 charges for you to consider. 1 open murder, 2 kidnapping. In the open murder charge, there are 2 theories that you can consider, both felony murder, first-degree felony murder, or first-degree premeditated murder. And the first element in both felony murder and first-degree premeditated murder is the same. And I'm required to prove that the defendant caused the death of Jessica Herringa. That is, Jessica Herringa died as a result of an act of the defendant. And there are a lot of things, a lot of pieces of evidence that you've seen over the last week and a half that go to show and prove beyond a reasonable doubt that, in fact, the defendant did cause the death of Jessica Herringa by an act. Let's start with June 29th, 2014. We heard in this case that a young woman by the name of Rebecca Bletch was found in a very rural, isolated, and desolate area, Automobile Road, in the northern end of this county, by herself. We know that as part of this, her personal belongings, her cell phone holder, her earbuds, and her sunglasses were on one side of the road. And we also know that in the middle of this road, we find a spent .22 long rifle shell casing. And what's important about that is the brand, CCI. We also know from the testimony of at the time, Detective Brian Harris, that very close by where Miss Bletch was killed and where her body lay in the roadway, he finds and discovers 2 more spent long rifle .22 shell casings, CCI brand. One, as if you recall in his testimony, one was a few feet, and then the other one was just a few feet from that. Very close in proximity to where, if you remember that photograph, where her head was. And that plays a very important role. We also know from the autopsy report that from her head, the doctor and the investigators collected fired bullet fragments. And we know that based on the location of the wounds themselves, that she was shot 3 times in the head, once in the back and twice on the side, that her manner of death was a homicide, and that the cause of her death was multiple gunshot wounds. And I want you to pay particular attention to wounds C and D. To me, ladies and gentlemen, C and D reflect where those shell casings 5 and 6 were found. In other words, shot execution style. We also know from discoveries that those handcuffs found in that black box where the firearm was found had Miss Bletch's DNA profile. In fact, it was 210 billion times more likely than it was hers than one unrelated, unknown individual, giving investigators a conclusion of very strong support that her DNA profile was on the interior of those handcuffs. If you look at the circumstances that you learned about in that particular investigation, that particular case, it certainly appears as though that was an abduction gone wrong. Then we go to April 16th, 2016, Madison Nygaard. At the time, she was 16 years old. And if you remember the testimony, again, we're in the northern part of the county, very, very rural, very isolated. Houses quite a distance apart, really not much as a way of commercial businesses along that roadway. And yet we find, in this particular case, the defendant creates another opportunity to collect a victim. Because if you think about it, ladies and gentlemen, as you have been listening to the testimony, what was the reason for him to be out there that day? What legitimate reason did he have to be out there in the northern end of the county looking in an isolated area, very close by the way, to where Miss Bletch was killed off an automobile road? We know that as a result, and you saw the collection by Detective Schultz of that Blueberry Farm video. And that video played a really important role in a couple of aspects. First, if you recall, you see that silver van going north on Weber Road. And there's a period of time before it comes back south. Quite frankly, ladies and gentlemen, as everything starts to unfold and as you look back and see how the evidence was collected and produced, the evidence does seem to show and suggest that during that brief period of time, that 3 or 4 minutes before you see that van coming southbound on Weber Road again, he's preparing not only the handgun, but also that insulin and getting it ready for his young victim, Madison Nygaard. We know that from the intersection of the Blueberry Field, you can see straight down Weber Road to the intersection of Weber and River. And what's interesting about that, and we heard this testimony this morning, that in an answer to a question about this particular matter, the defendant stated that he first saw her as he was traveling west on River Road. That he made this U-turn, if you will, down Weber Road, and let it slip, quite frankly, that, and I say, and I quote, "She wasn't where I needed her to be." And think about that for a second as you watch that Blueberry Field video. As he paused in that driveway before headed back south on Weber to River to make contact with her. We know from the video and from the testimony of Madison Nygaard that the individual that picked her up was in a silver minivan. And we know, based on the work of investigators throughout that in particular investigation, that they were able to take these images, not only get information from the Secretary of State, get information from the Chrysler Dodge people, and work in conjunction with other law enforcement partners to narrow it down to a potential suspect. And what's interesting about this is, as you heard from Mr. Brooks' testimony, what is significant to those who are familiar with Chrysler vehicles is that this particular vehicle was identified based on its black molding, based on the black handles, the door handles, based on the black side mirrors, based on that aerodynamic looking rear mirror, or rear window I should say, and the space between the last rear door and the wheel well. all making it available for them to come to the conclusion that this was a Dodge Grand Caravan manufactured between the years of 2001 and 2007. And you may be asking yourself, gosh, does that sound familiar? As we look back at the Jessica Herringa investigation and the identification made by Mr. Brooks at the Boyer coin. We know that from Madison Nygaard that it was a single male driver. There was nobody else in the vehicle, nothing else in the vehicle. And that ultimately she ID'd the defendant as the one who picked her up. Now, the other interesting aspect about this whole exchange between Ms. Nygaard and the defendant is this, is that as you heard Madison testify, she was interested in getting a cell phone in her hand so she could call somebody, her mom. She wasn't necessarily, in fact, at all looking for a ride home. However, in order for the defendant to get her in his vehicle, he said, look, you can use my cell phone, no problem, but you got to get in my car. Now, this is a young 16-year-old girl. As you can well imagine, probably a little distraught, a little upset as to what's happening. And she gets in that vehicle only to find out, the ruse as I like to call it, as she asks for the cell phone and the car starts driving away, he says, well, I'm sorry, the cell phone's dead. Can't use it. At this point in time, the defendant's probably pretty excited because so far, so good. And it makes you wonder, ladies and gentlemen, what did the defendant do or say to Miss Bletch before he shot her? What did the defendant do or say to Miss Herringa to get her to open that rear door? And we know from the testimony, ladies and gentlemen, that ultimately Madison, her antenna go up and she's really concerned because the defendant is not going in the direction that she feels safe. And ultimately, he pulls a handgun on her, points it at her. And you remember the testimony about this, whether there's an orange cap or not an orange cap, and she pointed out to you on the far right-hand side that plunger cap that we know protects the plunger of the diabetic needle. We know ultimately Madison Nygaard made a decision that very day that she decided she was going to fight for her life and jumped from the vehicle, the moving vehicle. She wasn't going to die. And you heard the description given by both Dawn Schmidt, the woman who called 911, and you heard from Deputy Blackmer, the first responding officer to the scene. And they talked to you and told you their observations about how she was when they came in contact with her. Dawn Schmidt talking about her hiding in the bedroom, hysterical, scared out of her mind. But you got more than that, ladies and gentlemen. You got a chance to hear the actual 911 call. The fact that, and you heard her voice, you heard her being scared, her being upset, her being just wanting to talk to her mom. You heard that for your very self. And the fact that investigators in their searches of all the locations involved in all these investigations never once found a toy gun or a fake gun. Quite frankly, because it does not exist. Just like Miss Bletch, this was another abduction that went wrong for the defendant. However, what's different about this particular one is that the victim escaped and was able to help investigators identify her captor. We know not only is this black gun produced for Madison, but when investigators go out and start investigating the actual scene, the scene where this incident took place, they find two very important pieces of evidence. They find two unfired long rifle 22 caliber rounds, CCI brand. And coincidentally, the stamp matches the stamp found in the ammunition box later discovered in the defendant's van. And as you look at the unfired round discovered in the Nygaard investigation compared to the unfired round taken from the ammunition, they look strikingly similar. And we also heard along these lines from Lieutenant Crump who in his 20-plus years as a firearms expert looked at these unfired rounds and made the determination, based on his experience and expertise, that they weren't weathered at all, that they in fact looked like they'd been run over. And if you remember, Deputy Blackmer and Detective Schultz talked about, more likely than not, it was Deputy Blackmer's patrol car that may have run these rounds over. And what's significant about that finding is that, as Madison told you, as she's running for her life, running out of her shoes, bleeding and injured, from the defendant in the defendant's van, she sees the defendant behind his van pointing the gun directly at her. And as she indicated, all she could think about is she didn't want to die. She had a family. Then we get to the statements that the defendant made as a result of this particular investigation, where he admits to being in the area and picking Madison Nygaard up. As indicated before, his statement about waiting for her to get in the right position before he made contact with her. And he indicated that she had in fact jumped out of the vehicle on North Green Creek Road. And what's significant about his conversation with Detective Schultz is that he lies about where he was that day. Ultimately, somewhat admitting to it as officers were showing them the evidence that they had against him. Then we know from his conversation with Detective Schultz that, and in his statements that were read to you earlier today, that the defendant in that interview admitted to being evasive. That his purpose was to not be honest with investigators. So let's talk about the discoveries now after the defendant is arrested. We have, excuse me, we have this Century safe and the contents therein. This particular, again, these rounds, these .22 caliber rounds, CCI brand. Again, similar to the rounds found in North Green Creek, but more importantly also, the shell casings being similar to the ones found at the Rebecca Bletch homicide scene. We know that this particular handgun is a Walther P22, which was found in the defendant's van. We know that the serial number was obliterated, making it, or an attempt to make it untraceable. But we also know that the Michigan State Police had the ability and the equipment to not only restore that serial number, but manufacturers, as you learned, also have a secondary serial number where they hide it. And from the testimony in this particular case, we know that that gun, that serial number, matches the purchase paperwork of Michelle Snotella. We know that from the testimony in this case that in 2012, Miss Snotella purchased this Walther P22 handgun. And what's significant about this purchase is that when it was purchased, it came already with a battery-powered laser sight attached and installed to it. We know from the testimony of Gary Foster, and you saw for yourselves, that the laser sight that was essentially given to the exact replica gun to the North Shores Police Department fits perfectly in Michelle's gun. And we also know from Mr. Foster's testimony that that particular laser sight was made for that gun, and that was the sight that was sold with Michelle's gun. Now, in any other case, that may not seem to be such a big, significant piece of evidence. But in this particular one, it means much more, in the sense that Michelle Snotella just so happens to be a co-worker of the defendant. We know from the evidence in this case that they worked in the same area in the same shift for a number of years. We also know from the evidence in this case that there were lots of conversations about this particular weapon, what it was, what it had. And those conversations included conversations with the defendant, which the defendant admits. We know that the defendant knows where Michelle lives. We know that he knows her habits. Certainly the one about keeping her doors unlocked if she's not traveling. And we know from Michelle's testimony and use of the Bing map that she lives right off of the snowmobile trail. We all saw that. That you could sit on that snowmobile trail and easily see the end of her driveway, the comings and goings, from a safe distance. We know from Ms. Snotella's testimony that she last saw her weapon, the weapon with the laser sight attached to it, at the end of February in 2013. And she remembers that date because there was people that her husband knew that were over for the weekend, and she remembers pulling the gun out and showing them her weapon. The other significant part of Michelle and Gwen Mogenberg's testimony is that in March of 2013, there was a significant period of time where the defendant wasn't working and Michelle was. And the records are there to show you. And we know from Michelle's testimony that that's the only time that she knows that he takes extended leaves of absence to go snowmobiling. We know from Michelle's testimony that she doesn't lock her house when she's going to work, that when it came to storing her weapon, it was stored in her closet in her bedroom, that in the same room where her weapon was stored, she also had her dirty laundry basket. And that becomes significant because of what investigators find in the defendant's shed. As we know from the testimony, investigators find, and this wasn't in some, if you recall the testimony, this wasn't in some location where if you looked and you saw, you would find it. This was actually tucked, as I believe Detective Peterson talked about, where essentially the attic of the shed and the roof line met. It was tucked beneath and under the rafters, if you will. Wrapped in tin foil and wrapped in plastic. And we know that there are two pairs, and that Michelle Snotella indicated in court to you, ladies and gentlemen, that those were hers. But we also know from the forensic work done by David Hayhurst on Record 18 that in the waistband of the red pair of underwear, there was a DNA profile mixture that contained both the defendant's and Michelle's DNA profile. We know from the pink pair of underwear that there were two stains examined. One that had semen and seminal fluid and semen in it, and one that was a female stain. And in Record 18, both of those profiles belong to the defendant and Michelle. And what's significant here, ladies and gentlemen, is that Michelle tells you that, look, the defendant's never been to her house before. She doesn't socialize with him. She didn't sell or give him her underwear, or the gun for that matter. And she knew of no reason why he should have either one of those. Now, what's interesting is that, as you learned today, the defendant in his statement indicates, well, Miss Snotella sold me that gun, and she gave me that underwear. And I don't know if you started experiencing this at all during the course of this trial, but anytime a piece of evidence looks really bad for the defendant, he always has a convenient answer to that question. And this, ladies and gentlemen, was a convenient answer. Because if we go back to the interview involving Detective Schultz and the defendant, Detective Schultz specifically asked the defendant, do you own or possess any other guns besides that Bursa, the one that he registered? And he said, no, I don't. Knowing full well that gun was located in his van underneath the driver's seat. And in fact, indicated directly that he lied about that. Now, if you purchased something legitimately or received something legitimately, why do you have to lie about it? There's no reason. There's absolutely no reason at all to lie about it. And quite frankly, if we look at Michelle Snotella, what's her motive? What's her motivation to come in here and lie about that? She's not going to get in any trouble. It's no big deal. Because it didn't happen that way. This weapon was stolen from her. These underwear were stolen from her. We know from the DNA work of David Hayhurst, based on a stain on the muzzle of that weapon, that the major donor matches the DNA profile of the defendant, and that's 1 in 1.9 quadrillion. We know the stain on the barrel inside the slide, the major donor of that stain matches the DNA profile of the defendant. That's 1 in 192 septillion. We know from the grip and trigger that the DNA profile matches the defendant. That's 1 in 6.1 septillion. Also, going back to Lieutenant Crump, we know that based on his expertise and the analysis that he does, that he analyzed both the fired .22 long rifle shell casings, and he also analyzed the fired bullets removed from Rebecca Bletch's head. And based on his expertise and his conclusions, he made a definite match to the Walther P-22 found in the defendant's possession in his van. Both the shell casings and the fired rounds were fired from that weapon. The defendant possessed the murder weapon that killed Rebecca Bletch. And what's interesting about that, too, and let's not forget about this, is that, again, weapon recovered, no laser sight. Weapon sold, laser sight. And that laser sight, if you remember from the testimony, was made specifically for the Walther P-22 that required 2 watch-style batteries. So let's talk about the toolbox. We know from testimony in this particular case and the note that was recovered from Bailey that that toolbox was an important part of this list of the defendants. In fact, he has, under kit, he has toolbox. And as you remember from Shar, the ex-wife's testimony, she never saw that toolbox before, didn't know it existed. Didn't know about the contents of that toolbox either. We also know that inside that toolbox was this. On the inside lip of that, or inside lid, is an injection site map. We know from the testimony of both Ms. Bishop and, for that matter, Dr. Rude, that there are classes that are given to folks who are diabetic. And in those classes, you learn about things on how to take care of yourself, certainly, but more importantly, the effect of insulin or the effect of overuse or underuse of insulin. And we know from Shar's testimony that the defendant was, in fact, a participant of those classes with her. And what's interesting about this particular insulin kit that I'm calling it, that was found in the defendant's van, is that we have an exhibit, Exhibit 131, which is the FBI lab report, which indicates that the liquid in the one syringe that is full is in fact insulin. The liquid in the Humalog bottle is in fact insulin. And if you recall from Dr. Rude's testimony, that he talked about 50 units. Those needles hold a maximum of 50 units. And in his testimony, he talked about the result of what happens to a non-diabetic individual when they're given 50 units of insulin. In his words, he said that would cause shock, i.e. incapacitation. We know from Dr. Rude's testimony that Humalog is a fast-acting insulin. In other words, it works quickly in the body. We know from the injection site map that there are certain locations that you can inject yourself to increase your chances of that insulin acting quicker than normal. One of those being the outside of your arm, if you remember that testimony. And what's interesting is that I think time is important when we talk about the collection of this. So this was discovered in May of 2016. A month prior to that, Madison Nygaard was being abducted on River Road. We know from Dr. Rude that transporting and keeping insulin in a safe like this isn't the right way to do it. We also know that the defendant admitted that he purchased both the black safe and stored the gun and the insulin in that. As part of this investigation, detectives discover these 2 video cameras in the toolbox, which is in the defendant's vehicle. Investigators also, as they unpack this, they find rope. And we know from the work of the Michigan State Police Crime Lab that the defendant's DNA profile was 64 million times more likely to be part of that mixture than if it originated from 4 unrelated people, offering very strong support it's present. The chain in this picture, again, defendant's profile, DNA profile is 820 sextillion times more likely to be part of that mixture than if it originated from 2 unrelated people, giving very strong support. His profile is on that. The J hook, which is on top of that picture, the eyelet part of that the defendant's DNA profile is 990 sextillion times more likely to be part of that mixture than if it originated from 1 unrelated person. Very strong support. The section of chain with handcuffs, the interior edge of those handcuffs, the DNA profile matches the defendant 1 in 283 sextillion. Lubricating jelly, or according to the list here, lube, also found. And we know from the testimony of Detective Lisa Ferris that that particular bottle of lubricating jelly was purchased at Meijer with the defendant's credit card. We also know that 2 notes were found with women's names on it, a handwritten one and a typewritten one. And we know from Detective Sergeant Flowers that on the typewritten one, he was able to identify the fingerprint of the defendant. We also know that in this toolbox was a ball gag. And again, on the red ball, the DNA profile matches the defendant 1 in 50 sextillion. We also know that the lab found the defendant's DNA profile in the leather straps, which matched the defendant 1 in 2.29 trillion. We also find the leather restraints in the metal bar. And again, in the swabbing of the inside of the leather restraints, we find the defendant's DNA profile, or the DNA profile matches the defendant 1 in 1.7 septillion. Other important aspects of this particular find is that black Mizuno glove. Swab of the exterior, the profile matches the defendant 1 in 473 sextillion. And the interior, the defendant's DNA profile is 66 sextillion times more likely to be part of the mixture than if it originated from 2 unrelated people. As part of the unpacking the black box that contained the handgun and the insulin and the handcuffs, we find 2 pairs of Adidas gloves. The exterior, the DNA profile matches the defendant 1 in 783 septillion. And in the interior, there was only 1 DNA profile which matched the defendant's to 1 in 20 quintillion. We also find additional sex toys, the silver bullet vibrator and the purple dildo. And we know from the Michigan State Police Crime Lab that the swab at the end of the purple dildo, there's a mixture of 2 DNA profiles found. The defendant is 79 billion times more likely to be a contributor to the mixture, which is very strong evidence. And Rebecca Bletch is 4,600 times more likely to be a contributor, which is a strong support. And that's important, again, to this whole idea of the defendant's desire to restrain and sexually assault women. The Reebok glove, which is pictured on the bottom of this picture. The interior of that particular glove, we find the defendant's DNA profile 70 quintillion times more likely to be part of that mixture than if it originated from 2 unrelated people, which provides very strong support that his profile is part of that mixture. And if you remember David Hayhurst's conversation or discussion about, in his initial review of this evidence and seeing what he believed to be small stains on the exterior, and he tried the hemostat and the other tests, they weren't very successful, and he described that some of these tests need bigger quantities in order to essentially get results. Ultimately, he did perform an exterior swab and did some DNA tests and found two profiles, a mixture, where in one of those, the defendant was 47 million times more likely to be a contributor to that mixture, providing very strong support. His profile is part of that. And also Rebecca Bletch, 90 quadrillion times more likely to be a contributor, which equals very strong support that she was part of that. And I won't go through the list. You guys got a chance to listen to it and see it. But clearly on his list, the kit, a part of this list, all, if not just about every single one of those items, is listed as an important piece to his plan. Then you heard testimony from Jerry McCarthy, the computer forensic expert for the Michigan State Police. And he talked about his analysis of the ASUS tower, computer tower, and the two Western Digital hard drives, which, as you learned this morning, the defendant admitted that he used, well, both the tower and the hard drives. And we got a chance to get a sneak peek, if you will, of the defendant's digital life, his footprint. We know from Jerry McCarthy's work that the defendant had, as part of his little subfolders, he had a folder called Homemade. And in that Homemade folder, he had several images of varying degrees that were, in fact, homemade. Secret surveillance, if you will. The first being the neighbor girls, the two juvenile neighbor girls that lived across the street from the defendant. And if you recall Jerry McCarthy's description of that, it wasn't as if the defendant was standing on his property and videotaping these girls. The video shows the defendant walking up to the bedroom window and through the slats videotaping these girls undressing, unbeknownst to them. And the defendant admits that he, in fact, did that. The 15,000 videos of swim meets, high school swim meets, which focused primarily, if you remember, Mr. McCarthy talked about the special infrared lens that essentially was like a see-through, made the camera almost see-through through the swimsuits. And the defendant's desire to videotape the breast area, the crotch area, the buttocks area of these young girls. Shar indicated to you in her testimony there is absolutely no reason for him, me, or anybody else related to go to a swim meet because none of the folks that they knew participated. And you got a sense from Mr. McCarthy the variety of high school swim meets that the defendant went to and took these videos, and in fact admitted that he took them. And quite frankly, one of the reasons is to think about and show his desire for juvenile girls, i.e., Madison Nygaard. The other homemade video that we talked about was that of Michelle Snatella, his co-worker, who he secretly videotaped in the parking lot, unbeknownst to her. We also know that the defendant had quite a collection of abduction, restrain, torture, rape, kill videos that the defendant himself admitted was his outlet. Quite frankly, ladies and gentlemen, the evidence seems to suggest that it was more than just an outlet. It was an opportunity to learn and to live out the fantasies that he wanted to live out. Because as Mr. McCarthy told you, he had thousands upon thousands of these videos. And it wasn't as though they were randomly located on this particular hard drive. No. As Mr. McCarthy told you, they were neatly organized in subfolders, labeled specifically on the subject matter at hand. In fact, as Mr. McCarthy told you, of the entire collection of pornography that the defendant had in his possession, a majority of that were these dark, sadistic, rape, kill, and torture videos. As Mr. McCarthy told you, the theme was the victims were always women. A majority of these women were young, blonde hair, and white. And I asked Mr. McCarthy in particular if any of those videos contained similar items that we find in this toolbox. And Mr. McCarthy told you that, in fact, these videos had women restrained by chains, by rope, by other restraints. He described in some detail the use of the J-hook, handcuffs, ball gag. And all these videos start the same way, with an abduction. They end up with the women being restrained, the women being tortured, the women being raped, and then ultimately they all end in the same way. The women end up dead by various methods: shooting, stabbing, hanging, suffocating with a bag. What's interesting on top of that is the defendant's fascination with serial killers, printing out that list of serial killers. And what's also equally fascinating is the emphasis, if you will, on that list, the tick mark on Lawrence Bittaker and Mr. Norris. Back in 1979, they were known as the Toolbox Killers. They used a van, and they went out looking for women who were alone and isolated to essentially abduct, restrain, rape, and kill. And he admits to printing this list out. One of the more important discoveries, this VIX file. Now the big file, the VIX file, and VIX, let's I guess make no bones about it. VIX stands for victims, plural. And I want you to notice something as that is broken down. But we don't have a victim listed. Madison Nygaard. And you need to be asking yourself, why is Madison Nygaard not on there? Well, because Madison Nygaard isn't dead. Defendant admits that he created and put the contents in those folders. The RSB, the FZ+C14, the secret code that stood for June 29th, 2014, the day that Rebecca Bletch was killed. The code for Jessica Lynn Herringa, JLH, coordinating with her disappearance, 4/26/2013. We know that in the subfolders, in one subfolder, the defendant had placed in there a video of a female inserting a tampon and had saved an entire website, an entire pornographic website. We also know one of those folders, in the Rebecca Bletch folder, contained images, personal images, lots of images of Rebecca Bletch herself, as well as one erotic one that wasn't her, but looked like her. We know from Jessica's folder, it contained pornography, child pornography, and many other personal images of Jessica Herringa, Dakota Dyer, and her son. We also know that within this arena, he had created a folder that contained an entire website from Fox 17 News on a story about Jessica Herringa. We know that he also created a folder titled Jessica on the 3-year anniversary that she went missing. And also important that Mr. McCarthy talked about was a 2013 spreadsheet that had purchases during that year. And as Mr. McCarthy tells you, there are several purchases from that Exxon gas station. This, ladies and gentlemen, was the defendant's personal digital trophy case. Because once these women were killed, he had to have images of them so he could remember. Whether it would have been for the thrill and the excitement of taking them, killing them. But as I've often told my own children, you don't get a trophy until you accomplish the mission. So we know up to this point that the defendant was ID'd by the victim who escaped. We know of the sizable amount of evidence proving the defendant brutally killed Ms. Bletch. And so in some respects, as we started this trial, you were able to see and I guess experience, if you will, the process that Lieutenant Mike Casher went through as this was kind of all unfolding, as he himself was working on the disappearance of Jessica Lynn Herringa. And ultimately, you were able to see the connection between all that, the defendant, and her disappearance and murder, as it became crystal clear. April 26, 2013. We know that Jessica was a single mom. She had a 3-year-old son at the time. And we know that she loved her son, that he meant the world to her. And we can see that in the photographs collected by the defendant. We know from diary entries that her son was never considered a mistake, but a blessing. We know that she worked at the Exxon gas station located on Sternberg in the city of North Shores. That at the time she had a live-in boyfriend by the name of Dakota Dyer. And as you recall from Mr. Dyer's testimony, he went through the last day of her life. That on that day they ran errands together. That because they shared a car and a cell phone and Jessica had to work that day, that Jessica dropped Mr. Dyer and their son off at his parents' house for dinner. That ultimately she goes to work, and during the day Dakota had the opportunity to check in and talk to her at least twice. One around the 8 o'clock hour, telling her, if you recall from his testimony, telling her that he was home from his parents. And ultimately one at the 10 o'clock hour, asking her to bring some groceries home from the store. What's interesting is that, like Rebecca Bletch and Madison Nygaard, Miss Herringa was isolated in the sense that she was working by herself. It was nighttime. We know there were no video cameras anywhere, whether it be the inside or the exterior of that store, recording anything that was happening. She was by herself. We also know from Miss Follett's testimony that it wasn't a secret about the video cameras to regular customers. And I remind you, ladies and gentlemen, about the statements the defendant made about his routine stopping at the Exxon, knowing who Jessica was, as well as the digital evidence that was discovered by Mr. McCarthy. Defendant knew her. In fact, he was there the day that she disappeared. And certainly, given the frequency, he would be a familiar face and voice. We know from the testimony of Eric Barber and Susan Follett that they're out enjoying a nice night on a motorcycle, doing a motorcycle ride. And that as they are driving down Sternberg Road, Miss Follett told you that she picks up out of kind of the corner of her eye this van driving on this silver van driving on the service road, almost parallel with them. And both her and Mr. Barber, as they are passing the Exxon station, see this van go in front, make its way around to the east side of the building, and cut its lights off. And it's at that moment that the red flags go up in Miss Follett's head, as she told you. And it's her suggestion to Mr. Barber that they turn around and go see what's going on. We know from conversation or the statement of the defendant as well as the Carfax report that the defendant had purchased a 2006 silver Dodge Grand Caravan in March 2013. And given Ms. Follett's testimony, when they made their way back to the Exxon station and parked in the Center Point Mall or the mall parking lot, the description of where that van was in relation to the back door. And in relation to where the blood, the battery cover, and the batteries were found. What's significant is her testimony as they get there and they're watching, they can't see what's happening in the back of the van. But they do see what I call the hatch action, where they both see the dome light come on as the hatch comes up. And they both describe to you this idea that the hatch came down but immediately popped up like something was in the way and then came back down. We know from the testimony of Ms. Follett that when the driver of that vehicle came into the light, she saw what she believed to be a red or orange shirt, not stripes, not blocked, solid color. We know from Detective Peterson the finding of a red and orange shirt in that pink bedroom, and we know from Shar's testimony that that room was where the defendant kept his clothes. We know from the testimony of both Mr. Barber and Ms. Follett that they cannot see any other movement in that van. In particular, as that van is making its way from behind the gas station to their location. We know that from their testimony that both of them looked at these photographs and said that that was consistent with the van they saw. And as you know from the testimony, it just happens to be pictures of the defendant's van. We get a little bit of a description from Ms. Follett, where she talks about the individual that she saw to be a bit heavier. And as she described, as that van was going by, she remembers seeing pretty blonde streaks. And we heard from Janice Horton, who was the hairstylist for the defendant for many years, that it wasn't uncommon for the defendant to ask for blonde streaks in his hair. And we know from Shar that was true even back in 2013. Ms. Follett provides a description to you, and I want, certainly, I know for a fact that Mr. Johnson's going to harp on this. But I want you to be very careful and remember her testimony about how she was trying to determine height. And in particular, in relation to Mr. Brooks' testimony in the height of the particular, in the area where she actually saw. Because if you recall, from essentially the driver's door back, she couldn't see because it was dark. The light in the back was turned off. It was only until the individual, the male individual, made his way to the corner of the building where the lights were that he was able to make a determination on height. And we know from Mr. Brooks' testimony that a Dodge Grand Caravan decreases pretty significantly in height as you get closer to the hood, if you will. Even at the driver's side door, from one point being 5'7" to 5'3", 5'3". And I also want you to remember the fact that it wasn't as though, as Mr. Johnson tried to do a demonstration with Mr. Brooks, we know for a fact that Susan was not that close. In fact, she was quite some distance away. Now, I guarantee you that Mr. Johnson will spend some time showing you the sketches and harping on the sketches and the fact that the sketches don't even come close to looking like his client. Therefore, you got to find him not guilty. But we heard the testimony from several witnesses that the defendant certainly looked a lot different back in 2013 than he does today, as far as his weight is concerned. We also heard from several witnesses who tried to describe facial hair as best they could. You know, was it closely trimmed? Was it scruffy? Was it a goatee? Was he clean shaven? Everybody was trying to do their best to remember. but I want you to remember a couple of things, including even Mr. Lieutenant Casher. I want you to remember a couple of things. Facial hair is easy to remove and is easy to grow back. And it's also important to remember this, that moment in time that Susan Follett had that opportunity to see, or to actually look inside the van, to try and make eye contact with the person driving that van. It was a matter of seconds. That van didn't stop. It kept moving. And not only that, she had to look through the passenger side window into the dark interior of that car. And I want you to think of this as he makes that pitch to you, and I know he will. This incident that happened to Jessica Herringa was not a random act. It wasn't as if somebody woke up and said, you know what, I'm going to go abduct somebody today. And I think I'm going to go to the Exxon station and see if I can, see if I can abduct somebody at the Exxon station. This was a carefully planned event. In fact, we know from the defendant's own cell phone records, the night before, he took the day off. And at 12:30 a.m., early that morning, he's at the Bailey House residence, calling his house. And maybe, just maybe, ladies and gentlemen, maybe he's just calling his wife to check in. Maybe she had no idea that he was even off that day. Because if you remember Shar's testimony, as of 2011, they really didn't communicate with one another. They were kind of doing their own thing. It was done right at closing time. Driving through the front to make sure that there's nobody, no cars, no customers, nothing to interfere with the plan. And what's interesting, that front to back movement, if you think about it from a common sense standpoint, if you remember the testimony, the staff had no control over the lights in the front of the station and on the sides of the station. The only lighting they could control was the back. What a perfect opportunity to take advantage of darkness by turning off the lights. In the store, there was no sign of struggle, which suggests that it was somebody that was familiar to Jessica Herringa. We know from the testimony of the defendant, as well as one of his friends, Mr. Warr, that he would frequent that area because he was into this Magic the Gathering card game. That he would go to Langs and play in these tournaments all the time. And that these folks, they would show up. And that Mr. Warr, if you remember, Mr. Warr obviously knew the defendant, knew him for many years because of that, but also knew the vehicle that he drove. And so the defendant is in an area that he's known and the vehicle is known. And ultimately we know that he likes to change his appearance given the fact that he had contacts in his little black kit. So common sense would tell you that given all that and the risk to the defendant, why wouldn't he change his appearance? We know that this vehicle turns north on Grand Haven Road, Old Grand Haven Road. Given both Mr. Barber and Ms. Follett's testimony, they follow this vehicle. And as Ms. Follett said, at no time, from the time they kind of came in contact with the vehicle to the time they got behind that vehicle, that silver van, did they see any movement in the vehicle whatsoever. We know from the timeline of the videos that were obtained that shortly after 11, investigators find and see a van, silver van, passing through that camera at May Consulting, the mattress store. We know, again, in the time sequence, a few minutes later, that same vehicle, that van, is passing through the old homestead, which again is on that route on Old Grand Haven Road. And we know from Jim McDonald's testimony, as he viewed the video from all three locations, that there was no time where the sequence was broken. In other words, this van didn't appear at the Mattress and Boyer Coin at the same time. Didn't appear at Old Homestead and Boyer Coin at the same time. They were all appearing in sequence, in order. We also know from Ryan Hehouse and Lieutenant Casher that in order to get to 3038 Bailey, going on Old Grand Haven Road, that is the most direct route. As you can see from Boyer Coin, Seaway to Getty, right on Summit, left on Bailey, and you're right there. We know from Lieutenant Casher's testimony this morning that it is approximately, at that hour, that 11 o'clock hour, it's approximately a 12-minute drive. Light traffic, more importantly, the traffic control devices are starting to turn into their flashing mode. They're not regulating. You had an opportunity to meet and listen to Larry Brooks. And Larry has been in the car business for a long time, 32 years, I think he told you, just last week. And more importantly, he's been working for the Chrysler Corporation for 32 years. In their product and design, works with the engineers, knows Chrysler cars inside and out. And what's interesting, at least I hope you found this part of his testimony interesting, is that car manufacturers take pride in the uniqueness of their vehicles. From what the taillights look like, to what the side mirrors look like, the door handles look like, the windows look like, the rims look like. So much so that they go through a legal process to make sure that not one single manufacturer, not one single one of their competitors can copy any one of their designs. It's almost like cars, every car manufactured is a unique fingerprint. And he talked to you about those many different aspects of the vehicle's design. But more importantly, he had the opportunity to review the Boyer Coin video. And as he told you and testified to in his process, he immediately said, that is a Dodge Grand Caravan RS, manufactured in the years 2001 to 2007. And he pointed to the reasons why. The black molding on the side, the black door handles, the black mirrors, the aerodynamic rear window. And that, as he told you, this was the only minivan that had those features. The only one. And I remind you, ladies and gentlemen, that we know the defendant owned a vehicle, the same vehicle, in that same model year range. We know at the gas station there was an altercation, that particular blood stain was collected by the police and later analyzed by the Michigan State Police Crime Lab, and it came back to Jessica Lynn Harrington. We know that investigators also recovered this, a Walther laser sight battery cover. And we know from the testimony of Gary Foster that in order for that battery cover to pop out the way that it did, it would require force. That some force, significant force, would have to be involved in order to pop that out. And quite frankly, ladies and gentlemen, you saw how he kind of struggled just removing the one battery cover from the Walther P22. We know that, again, from Susan Follett's testimony, that after they see the hatch come down, pop up, and then come back down, they see no movement in that van, which would suggest that that blood was based off of Jessica Harrington being hit with something. I would respectfully suggest that she was hit with that Walther P22, causing that battery cover to go flying. I would also suggest, ladies and gentlemen, that the defendant also employed the use of insulin. Because remember, as part of Dr. Rood's testimony, again, what 50 units of insulin means, the fact that Humalog is fast-acting, the fact what insulin has, the effect or the quickness that insulin works on a person who's thin, and more importantly, as Dr. Rood testified, when somebody's heart rate is beating rapidly, that is another factor that causes insulin to work very quickly in the body. And imagine being Jessica Herringa, being attacked, being essentially abducted, and fighting for your life, I would imagine that any human being put in that particular situation would have a very fast, quick heart rate. We know, again, the fact that he had access, the defendant that is, had access to all that. Going back to the battery cover, what's significant about the finding of this battery cover, and you saw, again, the demonstration that we did here in this courtroom. That cover, and you can see it for yourself in the picture, is manufactured for Carl Walther. In fact, Gary Foster, as well as I believe one of the investigators, said that they did some checking, and Mr. Foster sells guns for a living. That cover belongs to a laser sight manufactured for the P-22. And we know from the demonstration in court that the Walther P-22 that Mr. Foster provided to Norton Shores, equipped with a laser sight, that cover fit exactly onto that laser sight. More importantly, the testimony of Mr. Hayhurst and Ms. Schmidt. Mr. Hayhurst talked about, in his initial work on that battery cover, talking about seeing a profile that worthied, at least in his mind, moving it on to allow further examination and analysis under the new StarMix system. And more importantly, he talked about seeing male components to that profile. And we know from Ms. Schmidt's testimony that although it's a low number, it's not zero. The defendant is not excluded as being a potential contributor to that profile. We know from Clifford Barron that his wedding anniversary is the same weekend that Jessica Herringa went missing. We know from his testimony that he observed the Sunday after Miss Herringa went missing scratches on the defendant's face and arms, and a deep one near his thumb where one might hold a gun. I mean, Mr. Barron also talked to you about the reaction as the guys were kind of kidding around as to who might have taken Jessica Herringa, and Mr. Barron went and accused Mr. Willis, and he went crazy, threatening to turn him into management. And the fact that Mr. Barron talked about shortly after that is when Mr. Willis put bandages on his injuries. And when questioned about where those scratches came from, if you recall that testimony, the defendant told Mr. Barron, I was doing a brake job, or I was doing brakes and I got injured. Well, we know from the Carfax report he actually has a professional do his brake job. And Mr. Barron, who is actually a guy that works on vehicles, says, no, I don't see that happening. And quite frankly, noticed the fact that his hands were clean. And as Mr. Barron told you, working on brakes, you're not going to walk away with clean hands, even if you spend time scrubbing them. So, putting in perspective then, when Jessica goes missing, it received a lot of attention, local attention, a lot of national attention. People were out looking for silver vans. And this all is happening prior to Norton Shores following up on a tip involving the defendant. And quite frankly, this is all happening after Mr. Barron makes his discovery and puts the defendant on notice that those things are an issue. In fact, if you recall from the testimony, both Sergeant Baker and Corporal Hare do not come in contact with the defendant until some 12 days later. Plenty of time to heal. Plenty of time. Both talk about viewing the van. Both talk about seeing that the van looked really clean. In fact, I can't remember if it was Sergeant Baker or Corporal Hare talking about the fact that this van had fresh vacuum marks in it. The defendant, when asked, hey, what were you doing that night, admits to being in the area, admits to being at the Exxon station at 5 o'clock and buying mitts, and admits to being at the mall playing this card game, but tells both Sergeant Baker and Corporal Hare that he is done by 9:30, he's home by 9:45, and he doesn't go anywhere until 12:30 a.m. the next morning. And what's interesting about that is that he decides at 12:30 a.m. to go to his grandfather's house on Bailey, where nobody lives, to pick up a board for a dog gate that doesn't need to be repaired. And then decides that he's going to go to Taco Bell. But what's interesting is that he chooses the Taco Bell not by his house, which is closer. He goes back to the Taco Bell near the crime scene. Given all his other interests, it's clear that he wanted to see how his handiwork turned out, what was going on. Because as Lieutenant Casher said, there was kind of a flurry of activity, and it was just getting started around that 12:30 time. We know from the testimony of Sergeant Baker and Corporal Hare that they asked to speak to his wife and were told that she was unavailable. But we know that's not true, because Shar said, hey, look, I was there, I looked out the window, I saw our van doors up, I saw the officers kind of looking through it, and I was unaware at all that that they wanted to talk to me. The defendant never told me. I never knew. And in fact, when they asked for the cell phone and were told, well, my wife has it, I can't give it to you, the cell phone was sitting right there in the living room, according to Shar. What's interesting about that also is you heard the answering machine message from Corporal Hare to Shar saying, hey, look, Corporal Hare, we're just kind of doing some investigation. I'd like the chance to talk to you. And Shar listened to that and said, I never heard that message. Never knew. I never knew that Norton Shores Police Department wanted to talk to me. The defendant never told me. Hare calls back, saying we don't need to talk to you anymore. And she never heard that one either. And in fact, if you think about it this, ladies and gentlemen, from a common sense perspective, if in fact Shar had actually reached out and talked to investigators or Corporal Hare or Sergeant Baker, why would Corporal Hare have to call back saying, hey, don't worry about it, we don't need to talk to you anymore? There was no need for that phone call if that conversation happens. It didn't. We know that this particular phone message was found in the camera bag in the defendant's shed, that the camera battery in that bag had a stain on it, and that stain matched the DNA profile of the defendant, 1 in 13 billion. We also know that Mr. Hayhurst swabbed the strap of that particular bag, and the defendant's DNA profile was part of that, 1 in 4.7 quintillion. More importantly, though, is a review of the defendant's statement versus what the phone records tell us. And remember, the defendant tells Sergeant Baker and Corporal Hare that he is at home from 9:45 to 12:30. Well, according to his cell phone records, he's not. That at 11:23, shortly after Miss Herringa goes missing, he's bouncing off the tower that encompasses the Bailey residence. And we know for a fact that he's not home because it's his home calling him. That call goes unanswered. Then we get a second call, 11:59, still bouncing off the tower that encompasses 3038 Bailey. At midnight, as Sergeant McDonald told you, the particular phone that the defendant had in the service, when you missed a call, the company sent you a message saying, hey, you missed a call. And that's what this represents. At midnight. So, 2 calls from the residence, 11:23, 11:59, home calling defendant's cell phone. Then finally at 12:05, defendant calling home, still bouncing off the tower that encompasses 3038 Bailey. He wasn't home that day. that night. He was at 3038 Bailey with Jessica Lynn Herring. Why is this an ideal location? We know from the testimony that since 2011, nobody lived or resided at this house, that it was empty. We know from the defendant's testimony that he himself padlocked the entrances, had the key for the padlock. Certainly had access to this home anytime he wanted. Quite frankly, he created, as part of his overall fantasy, the perfect torture safe house, the sanctuary, where he could make his videos a reality. We know from Ryan Hehouse that he did a very extensive scan and continues to do this scan at a local, state, national, and international level, looking to see if anything pops up that shows that Jessica Herringa is alive somewhere. Not only in this area, this state, this nation, but this world. Including, as he testified, facial recognition software. With no luck. 0 positive results. As part of this element, ladies and gentlemen, we heard from Mr. McCarthy and his experience as a forensic computer analyst. More importantly, at the end of his testimony, I asked him this question: in your experience, how do people pick passwords? Why do people pick passwords the way they do? And he talked to you about people usually pick passwords. You can think about your own experience. You pick passwords that have meaning to you, that you will easily remember, because, as Mr. McCarthy said, we live in a world now where everything you touch digitally requires some username and some password. And so you pick passwords that have meaning, special meaning to you, that you will have no problem remembering, not forgetting. Examples he gave, like kids' birthdays, anniversary dates, wedding dates. And what's significant about this, ladies and gentlemen, is that on April 26, 2013, the entire community, the state, and the nation, everybody knew that on April 26, 2013, Jessica Herringa went missing. But there's only one person who knows when she died. And that was the killer. And what's significant about that, ladies and gentlemen, is this. In 2010, the defendant used his daughter's name and birth date as his password. In 2015, it changed from his daughter's name and birthday to J427L13H13. 4/27/13, the day Jessica Herringa died. Ladies and gentlemen of the jury, as far as element 1 is concerned, as you look at the totality of the evidence in this case, the evidence proves beyond a reasonable doubt that not only is Jessica Herringa dead, but she died at the hands of the defendant. The second element I'm required to prove is that both, and this is both for premeditated and felony murder, that he intended to kill Jessica Herringa. The defendant intended to kill her. Now, the court's going to give you some guidelines to help you determine that intent. For example, you can look at what he said, how he did it, or by any other facts and circumstances. And you can also include the other acts of evidence that we've been spending some time talking about to determine intent. And believe me, ladies and gentlemen, I'm not going to rehash this over and over. But I will point out to you, as you look at the crime scene, we've already gone over the connection to the P-22 and the defendant. In other words, there is a clear connection that the gun that he stole from Michelle Snotella back in March of 2013 is the same gun he used to subdue Jessica Herringa in April of 2013. And I want you to also look at how he dealt with Miss Bletch. In particular, as we talked about in the beginning, when Miss Bletch decided to flee for her life, the defendant took it upon himself to not shoot her once, but shoot her 3 times, 2 times at close range, execution style. Clearly an intent to kill. The Madison Nygaard scene, the unfired rounds, again, those rounds that are exactly the same as the rounds found not only in the gun itself, but in the box of ammunition. His obsession with the dark porn education videos. The fact that in every single one of those, at the end of every single one of those videos, the victim ends up being killed. The restraint tools. And quite frankly, from a common sense standpoint, how in the world can you continue to carry out your sick fantasy if your victims survive? I.e. Madison Nygaard. In order to continue with his obsession, he had to make sure that every victim he came in contact with ended up dead. Clearly proving that he intended to kill Jessica Herringa. The third element for premeditated murder is that the intent to kill was premeditated, that is, thought out beforehand. So in other words, preparation. And again, I'm not going to rehash everything, but if we highlight a few things, I go back to the night before Jessica went missing. Intentionally took the day off from work. Went to 3038 Bailey in preparation. Scoping out the location and the victim, becoming familiar with Jessica Herringa's work hours, the work pattern, understanding that the station itself had no video surveillance system in order to capture this deadly deed. The purchase of the van itself. I remind you about the toolbox killers. The fact that he took the time to steal Michelle Smotella's gun and then make it untraceable in his mind by trying to scratch off the serial number. Ladies and gentlemen, this note, this checklist, if you will, of the things that he needed in order to accomplish his mission. Certainly the toolbox, as we've gone through, and its contents. The fact that he carried in his van this loaded gun and this insulin kit. The creation of 3038 Bailey. The opportunity that presented to him, in other words, a sanctuary where nobody would know what he was doing down in the basement. Certainly making her body disappear as part of his plan. Disposal of the evidence. Because again, I go back to this idea that you cannot continue committing these crimes if your victims are alive or found. The fourth element of premeditated murder is that the killing was deliberate. In other words, he considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been a real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. There is no rule as to the time required. It is up to you to decide if enough time has passed. And again, if we look back at the evidence presented as well as the elements of intent to kill, certainly, given the time frame that we're talking about, the defendant spent hours with Miss Herringa in his basement on Bailey. Plenty of time to look and reflect prior to killing her. And again, I ask you to think about the other acts in this case. The 3 shots, including the 2 at close range that killed Miss Bletch, and the attempt to try and shoot Miss Nygaard. We talk about felony murder, which is another theory that you're allowed to consider in this particular case. That when the defendant did the act that caused the death of Jessica Herringa, the defendant was either attempting to commit the crime or committed the crime of kidnapping. And again, the law allows you to use this other act's evidence in order to help you make the decision in this particular matter, as well as what we know about the Herringa crime scene. The judge will read you the instruction and the definition of restrain, but if we use our common sense, restrain is pretty common sense. We know that Jessica was alone at the Exxon station, that she was last seen by Susan Mosley just before 11 o'clock, and she wasn't in the Exxon station when Mr. Harpster arrived around 11:07. We know about Jessica's blood in the laser sight parts, but more importantly, we know about the condition of the inside of that store. No money missing, no product missing, nothing disturbed, all cash accounted for. Jessica leaves her car, her coat, her purse that contained her money, her ID, her wallet. The back of the van action, this idea that the van comes down, gets caught on something, pops up, and then it is pushed down. The fact that nobody sees any movement in the back of that van when it drives by Susan Follett and Eric Barber. The defendant's video collection, that restraining the victim, is always part of it. The toolbox that contains all the restraint tools. The fact that the handcuffs included the DNA profile of Rebecca Bletch. And so in some respects, we can come to the conclusion that perhaps when he subdued Miss Herringa, he put handcuffs on her to make sure that she didn't move. The fact that Miss Nygaard was restrained in the van at gunpoint. And certainly, I keep going back to this list. As part of his kit contains several items of restraint, including large and small zip ties, restraint board, restraint bar, handcuffs, all with the idea of restraining. 3038 Bailey, an area that the defendant controls, that he put the locks on. The video timeline from the stores that puts him in that direction, going in that direction, the night that Jessica Herringa went missing. All show the defendant's intent to restrain Jessica Herringa. The other element that I have to prove is that when he did so, when he restrained her, he intended to do one or more of the following. You're going to hear the court, go through a list, but clearly, given the evidence in this case, the defendant's purpose, his intent, when he restrained Miss Herringa, was to do so to engage in criminal sexual contact, or penetration. Now, as I come to a conclusion here, ladies and gentlemen, I guarantee you, as I've indicated before, that Mr. Johnson will more than likely go back and say, well, look, prosecutor talked about this DNA stuff, but none of that stuff had Jessica Herringa's DNA on it. Her profile wasn't located. If you remember from my opening statement, I was very transparent about that. I knew that going into this case. But as I hope you can see, that a criminal case can be more than just DNA results. That there's plenty of evidence that presents a beyond a reasonable doubt picture that puts the defendant guilty of these crimes. And I want you to remember the fact that as the experts talk to you about how fragile DNA is, the elements, the weather, the conditions, how an object is stored. Mr. Hayhurst talked about the quantity and the quality of the DNA. More importantly, chemical agents. As Mr. Hayhurst talked to you, they use bleach in their laboratory every time they go from one case to another to make sure that they sanitize down the area where they work. And let's not forget, ladies and gentlemen, the number of bleach bottles and boxes of powdered bleach that were found in the basement of 3038 Bailey. And as Shar told you, who was the caretaker of Grandpa Ham, one of the caretakers, if you will, prior to his death in 2011. So from 2005, when the woman who was taking care of him passed away, to 2011, Shar was one of the main caretakers of Grandpa Ham, was at that house more often than she wasn't, doing the cleaning and the grocery shopping and taking care of Grandpa Ham. And she said, look, I knew that house up, down, backwards, and forwards, and I never saw any of that when I was there. In fact, if there was anything like that, we usually broke it down and threw it away. It didn't stick around. What's important to remember is that the defendant had years to clean up. Years. The officers talked about 12 days after the event, his van was pristine clean. Imagine if you had 3+ years, what you could do in order to make a crime look like it never happened. I want you to focus as we talk about this checklist. This top portion. Top portion talks about clothes: shirt, pants, underwear, her panties, socks, shoes, hoodie. Remember Dakota Dyer's testimony that when Jessica worked the night shift, the closing shift, she would wear a hoodie because when she closed and had to refill the cooler, she used that to keep warm. Last entry, coat ? Remember from the crime scene that Jessica's coat was left behind. Ladies and gentlemen, part of this list is a checklist so the defendant knows and remembers to collect the things that he needs to collect in order to make sure that his identity and her whereabouts are unknown. In fact, as part of this list, we talk about gas can and matches. What better thing to do than to burn the evidence? And again, I go back to my initial comments. It's hard to continue with your criminal activity if you leave evidence behind. We know he was kind of successful with Ms. Herring. Not quite, but kind of. And maybe he got cocky and arrogant when it came to Ms. Bletch and Ms. Nygaard. Because by the time Ms. Bletch is being killed, he's gotten away with murder once and it's been 2 years. So, as we think about that, the time he had to take care of the evidence. Again, ladies and gentlemen, I want to thank you for your attention and your time and your patience. And allowing me to spend at least this long period of time in order to kind of walk through with you the evidence that was presented in this case and how it relates to the guilt of the defendant, both on count 1, whether it be first-degree premeditated or first-degree felony murder, he's guilty of that. In count 2, kidnapping of Jessica Lynn Herring. Thank you.
Okay, thank you, Mr. Hilton. Before you start your closing statement, I think we'll give the jury a 10-minute break.
Thank you, Your Honor.
So we're going to take a 10-minute break, and we're going to come back, and Mr. Johnson's going to make his closing statement, and then Mr. Wilson's going to give his rebuttal, and then I'm going to give you an instruction. Okay? We take advantage of this opportunity to refresh. Wait for this. I see.